so much, but I'm very happy that we did so, because very soon, within about a month of being appointed, or even less, he has been able to put together this very important program. I was told that basically the registrations got, we have a limited number in this hall which we can accommodate, and that number filled very, very fast, and I think we have on Zoom as well. So this is the first of a series of workshops like this to help you all in your journey to the legal profession, and of course to make the legal profession a better place. That is our responsibility and duty to do what we can. But as I said at the beginning, all of you are the future. And it is our responsibility to build you, and it is your responsibility to take what we provide and do better than all of us. So that is why we have with us Professor Sanath Samira Vijayasinghe, as I mentioned before, the youngest professor of law in the country, I think in the history. Yes, so next to Professor Piris, and we know how far he went. And he's going to speak on an interesting topic on research excellence. Something I always say is, well, all of you, I'm sure, have some knowledge of research, but as a senior and as someone who has juniors working for me, I always notice that some juniors, some lawyers are better at doing research than the others. So, for example, if I ask somebody to find something or find some case law, always I know somebody will, I know the person who will give it to me faster than the others, which means research is also like a science. There are ways you need to know what you're looking for, and you need to know where you're looking for. And of course, that is a very primitive way of putting it. This, I think your lecture will be much more scientific in nature, but this is important. We will also conduct many more programs such as this. I also want you to have close association with this committee, because we are now presenting to you what we think you need to know. But I think we need to also find out from you as to what other areas you need to support. I have made open invitations both to the law faculty in Colombo and also the Sri Lanka Law College. We are ready and willing to support. The president of the student union is here. I know they have helped us a lot, and thank you. We will give whatever assistance, what we can. We'll make available all our resources. Please make use of the online programs we do, the webinars which go out. We have a repository of webinars of now over 200 on the BSL YouTube channel. Something I always tell young lawyers is, if you have the patience to watch all those YouTube videos, I can assure you that you will know more law than most of the lawyers we have. It covers all of the topics. And I'll just take 2 more minutes. I have lawyers who have told me when they go to the gym, they put the headphones off and listen to a webinar. There are others who, when they drive long distance, you don't need to see the people, you just need to hear the ride. There are those who maintain files. And we have, I think, 200 or plus, no, we had 175 original, then I think the last 2 years they did some. And we've already done, I think, 11 or 12. Please start watching those as much as you come here. And you have my assurance that you will know more than many lawyers, because it's knowledge. So I once again thank the committee very much for this, and I hope to see all of you on a more regular basis at the Bar Association of Sri Lanka. Thank you very much.
Thank you very much, sir, for your insightful and motivating words to set the tone for the workshop. So now I invite Dr. Malraj Kiruyalla, Attorney at Law, Chairman of BASL Standing Committee on Law Student Skills Development, to give us an overview on the workshop series and to introduce today's guest speaker. Sir, stage is yours.
Good afternoon. President of the Bar Association of Sri Lanka, Mr. Rajiv Amrasurya. Guest speakers, Professor Sanat Samira Vijayasinghe, Treasurer of the BASL, Mr. Pasindu Silva, Assistant Secretary of the BASL, Mr. Salinda Jayawardena, dear participants. It's a great privilege to start this session of the Students' Legal Skills Development Workshop Series organized by the BASL Standing Committee on Law Students' Skills Development. Starting with this workshop, this series aims to equip law students with practical skills often overlooked in formal education, like the legal research, public speaking, professional etiquette, and more. We are bringing in top experts to ensure you learn from the very best. Today we focus on legal research, the foundation of any successful legal career. We received a remarkable number of registration, and due to limited space, physical participation had to be restricted, with the rest given the opportunity to join online. Thank you for your enthusiasm and for being here today. I would also like to take a moment to acknowledge the valuable support of the student unions from legal education institutions across the country, especially the Sri Lanka Law College Student Union, for helping to coordinate student participation. For today's session, we are truly honored to have an eminent and inspiring expert with us. Professor Sanat Samira Vijayasinghe is the head of the Department of Legal Studies at the Open University of Sri Lanka. He holds an LLB with honors and LLM with merit from the University of Colombo, a PhD from Queensland University of Technology, Australia, and earned first-class honors at the Attorneys at Law final examination. His excellence has been recognized with prestigious awards, including the Dean's Award and Gold Medal for Jurisprudence, as well as Research Excellence Awards from the Open University of Sri Lanka. His work spans intellectual property law, health justice, and international economic law, addressing critical real world issues while also teaching and mentoring the next generation of lawyers. We are truly privileged to have him here to share his insight with us. Please welcome Professor Sanat Samira Vijayasinghe.
Okay, very good afternoon. So thank you very much for the kind introduction, Dr. Malraj. And thank you very much for the invitation also. It's a privilege as well as an honor to stand here today. So President of the Bar Association of Sri Lanka, Mr. Rajiv Amrasurya, and the Secretary, Additional Secretary, as well as the Treasurer of the Bar Association. And so we'll be having 1.5 hours to discuss about like so many things. I don't know how to sum up some things and just to provide you with that the additional specifications also, but I'll try my best to sum up things especially relating to legal research. Okay, so this is the topic that I'm going to discuss with you. Before going into the outline or the roadmap of the presentation, so I would like to quote Thomas Jefferson, He says a lawyer without books would be a workman without tools. Okay, which this very idea of Thomas Jefferson's includes 2 points. First one is foundational role that research, reading, and knowledge plays in the legal profession, and effective advocacy and sound judgment are deeply rooted in rigorous and continuous legal research. Okay, so intentionally or unintentionally, whether you like it or not, so you have to get ready as a practicing lawyer or perhaps a legal researcher, research associate, to go through relevant provisions of the legislations as well as case law and sometimes authoritative works also. Okay, in that event, you will be engaging in a type of legal research. Okay, the only thing is that, so we have to have some training prior to engaging in legal research, which is lacking in most of the law teaching institutions. Luckily, Colombo University, they have introduced research methodology in their curriculum. Open University, we introduced a new curriculum to the Open University. In the 3rd year, they have a compulsory course called research methodology. So we have completed the research methodology course material, which will be printed in next month. So likewise, law college also, I think it would be the high time, or the better, it would be better to consider introducing legal research method into law college curriculum also, not as a kind of a separate heavy course because you are overburdened with existing subjects, but as a kind of a module which needs to be completed as a part of your attorneys at law examination, so that the study. Okay, so there is another quotation which I have taken from Professor Granville Williams' famous book, Learning the Law. He says that the person who wants to become a lawyer and not merely to pass law exams, must learn to use legal materials, A complaint made with increasing frequency is that too many modern graduates are unable to conduct research, by which is mean, amongst other things, that the students have not been taught how to handle legal materials. Okay, so it is very important for us to provide students with some guidance on how to handle legal material. I actually appreciate the effort taken by the Bar Association of Sri Lanka in taking the task, shouldering the task of educating or providing some knowledge to the students on how to handle legal material. It is a kind of a response to the statement of Professor Granville Williams. That is how I see it in the law book. Okay, so this is the roadmap. So I'll be briefly discussing about importance of legal research and research planning, sources of law and legal databases, research ethics and citations, which is very important because perhaps you might know that there are so many that the incidents in India and other courts that lawyers have cited fake cases using ChatGPT and other relevant artificial intelligence platforms. Okay, so there are chaos as well as ideas for as well as against of using ChatGPT for academic and research work and also court works also. Okay, and then I'll be very briefly touching case-based research techniques, and then I would like to give you some practical tips for academic and research success, followed with the summary. When it comes to the importance of research, research is a kind of a systematic process. Okay, so we all engage in research. Research means that very term can be divided into 2 parts. Research, you are searching something which is available in existing knowledge. You are searching about something which is available in existing knowledge. Okay, the result of such search would be a novel contribution to the existing knowledge also. Okay, so research is a systematic investigation on a particular or that selected topic. So what is the meaning of legal research? So legal research can be described or defined as a systematic study of a legal topic aiming at finding things out. A systematic study of a legal research with an intention of finding things out. For an example, we know that artificial intelligence has posed so many challenges on conventional laws. For an example, artificial intelligence and data protection. Artificial intelligence implications on intellectual property rights, whether we can recognize and accept non-human inventors and non-human authors in the context of existing or the conventional provisions of the Intellectual Property Act. Artificial intelligence and online consumer protection or consumer protection. Artificial intelligence and cyber crimes. Okay, so these are the things or the issues which may need to be the further investigated and solutions or the legal proposals need to be introduced also. Okay, a systematic review or the investigation of a selected legal topic can be simply considered as a legal research. Okay, so there are so many different avenues or that the purposes or objectives of legal research, as I mentioned here. So a law research can be conducted to guide government in formulating laws. Perhaps, we never know, your research can be utilized by lawmakers of the government or the lawmaking authorities to introduce new laws. Okay, introducing a new law relating to protection of privacy or the right to privacy. Okay, and then to support solving operational and planning problems about business, industry, market, and society at large. This is not an exhaustive list, okay? So there may be some other objectives of legal research. However, these are some of the main objectives of legal research. And to help the judiciary entrust that rights and freedoms are protected, respected, and fulfilled in the administration of justice, and to help lawyers in arguing at the courts. Okay? So, to help lawyers in arguing at the courts is also one of the objectives of law research. This is an example of a research published in an international journal. I was one of the authors of this particular article. So look at the title of the article. The proposal for waiver of WTO TRIPS agreement to prevent, contain and treat COVID-19, investigating the benefits and challenges for low and middle income countries. Okay. So you can conduct a research because when you are doing a research, you are not supposed to reinvent the wheel. What is the meaning of reinventing the wheel? If it is there, if answers are also there is nothing to worry about. Okay? If there are no answers to a particular problem or question, then we need to engage in a kind of a systematic study on that topic to find answers. Okay? So, when we are doing research, before actually starting the research process, research is a process, I'll explain to you. So, I will explain the research process. So, before starting the research, I think it would be better to do some further readings. Okay, I'd like to share an example with you. So, one of the PhD students of mine, she wanted to do a research on protection of AI generated inventions in Sri Lanka. Okay, so when we had the meeting, first meeting, initial meeting, so I felt that she seems to be having not having the enough background knowledge about the topic. Okay, then I asked her just to go through 10 journal articles published on the relevant topic and prepare a kind of a write-up, like 1,000 words write-up, just summarizing these 10 journal articles. Okay, then she came to me with the write-up and said to me that, sir, I think we need to change the topic. I think we need to change the topic because after having a thorough analysis of existing knowledge, only she realized that she needs to be She needs to change the focus because it is really difficult to no point of actually discussing, recognizing AI related inventions, so AI based invention in Sri Lanka, because we don't have specific laws when we are looking at the global level. Also, even in other countries, they don't have a specific laws, okay, regarding this inventing. So recognizing AI generated or AI based inventions. Okay, then we slightly change the topic, looking at like theoretical and practical dilemmas or debates surrounding or revolving around this patenting, or that the recognizing providing patent protection for AI based or AI generated or assisted inventions. Okay, now she has a problem to investigate because there is lack of research or knowledge on that topic. Okay, so when you are doing a research, legal research, apart from the research that you do in your day-to-day life, so it would be better to like do a kind of a background research to identify whether there is a researchable question on or relating to the selected topic or not. If there is no such researchable thing, no point of conducting a research. So as I mentioned, research is a process. So you need to find out a problem. Then to answer this problem, we have to have a kind of a design which is called methodology. Because there may be different questions. For an example, assume that you are going to do a research on legalizing abortion in Sri Lanka. Okay? Legalizing abortion in Sri Lanka. So abortion is a delicate issue. Delicate in the sense abortion intersects with other aspects also. It is not only a legal issue, it has some connections with other aspects like cultural aspects, religious aspects, economic aspects, and societal aspects also. Okay, so you can take a decision, like there may be two decisions, just only to stick into this legal aspect of abortion and discuss it and like make some proposal saying that okay, these provisions in the penal code needs to be changed or amended accordingly to legalize abortion in Sri Lanka. Or perhaps if you are keen in investigating the social compulsion or that the connectivity with law and society, perhaps following an approach like that the very clearly discussed by legal philosophers like Roscoe Pound and Eugene Ulrich in sociological jurisprudence, you could answer the legal issue, but at the same time looking at non-legal aspects of abortions also. Okay, you are not supposed to be an anthropology researcher or a social science researcher or economic researcher or psychological researcher just to investigate these non-legal issues revolving around the legal issue of abortion or the context of legalization of abortion. What you can do? You can simply go through the existing knowledge or that the published articles. There may be reports published by Ministry of Health in Sri Lanka. There may be reports published by social science researchers regarding different aspects of abortion, like social science aspects of abortion. So you can simply go through these published articles and knowledge and then like analyze them and connect these research findings into your issue. What is the issue that you have in your hand? Legalization of abortion. Under what circumstances we should be legalizing abortion in Sri Lanka, because Sri Lanka is a multicultural, multi-ethnic, multi-religious country. We may not be able to follow the US example. We may not be able to follow the Australian example or Denmark example or examples from sophisticated jurisdictions as it is because of the country specific or contextualization related things. Okay, so that is why rather like confining into like black letter law, it would always be better to looking at other aspects help like the developing law. Okay, so then you need to design your methodology, okay, how you are going to collect data, and then using that design or that the methods, we need to collect the data, which means information relating to the selected topic. And then we have to analyze the collected information. Okay, there may be lots of different methods of data analysis. I'm not going to discuss those methods here. I don't want to make this discussion a kind of a very complex and rigorous theoretical and technical one. Okay, I just want to touch the periphery of legal research with you. Okay, and then after analyzing, we are supposed to propose the findings of the research. Okay, so that the presentation can be in different forms, like could be an abstract, could be an extended abstract, could be a dissertation or a thesis or a presentation, or you may be submitting a paper to a journal. Okay, you have Manurava Law Journal and Meeson Law Journal in Law College. In Colombo University, they have Sri Lanka Journal of International Law, Colombo Law Review. In Open University, we have Sri Lanka Journal of Legal Studies. So these are like, the publications that you can consider submitting your work, because research findings need to be presented somewhere. Otherwise, no point of the keeping findings of research with us. Then, when we look at the terminology of law research, it is very important, this term, research problem. Simply, research problem define an educational issue or problem within a broad area. Educational issue specific laws. Okay, Sri Lanka is having an aging population according to this demographic data. So we may need to consider that the regulating most of the aspects relating to public health and health law. Okay, introducing new laws. So then when you select a broad area, this broad area can be divided into that the specific areas. Intellectual property, under intellectual property, marks, patents, industrial designs, geographical indications, so on and so forth. Okay, then you can select one such area and then look at the contemporary application of this particular area. For an example, regarding intellectual property, once again, the AI example. Whether an image created by an AI or AI chatbot or using AI application can be considered as an original work, which can be protected under section 6, 7, 8, 9, 10, 11, 12, 13, 14 of the IP Act of Sri Lanka or not. Okay, so you have to select a broad area first and then divide that broad area into sub areas, and regarding each and every sub area you need to look at whether there are impending issues which needs to be answered or compelling issues which needs to be answered. Okay, then you can select one such area and conduct a research, because we are not supposed to discuss the whole area, because we may not be able to provide the comprehensive answers to a particular context or that an area of law. Okay, then once you, this is an analogy actually, just to explain the term research problem. So research problem is something similar to that identification of the destination. Okay, once you identify the destination, then you can plan your journey. Research problem is something like that. Okay, so you have to identify the issue at hand or that the issue, then you can design your research journey. Okay, what is the method that you are going to collect data, how you are going to collect data, and how you are going to analyze, and how you are going to present it. For an example, if you are going to do a research on legalizing abortion in Sri Lanka, so then seemingly you have identified the destination. Now you have to plan the journey. Okay, so you may think that abortion is not only a legal issue, it is an issue intersects with other aspects of the society. So I'll be looking at societal aspects also. Okay. First, you need to identify what are the available laws in Sri Lanka which supports or which prohibits or restrict abortion. Okay. To find out that information, you can simply refer to primary and secondary sources. Primary sources means legislation and case law. Secondary sources means all other relevant materials like books, articles, blog posts, YouTube videos, so on and so forth. All other material discuss about this primary sources. Okay. Then you opt to discuss about the social construction or the social stigma, religious aspects of abortion. In that event, perhaps you can select a research methodology called socio-legal research method to find out what's happening in the society, or what are the social perspectives, what are the religious perspectives of abortion in Sri Lanka. Perhaps you can conduct interviews, selecting the key informants. You can conduct interviews like face-to-face interviews just to obtain their ideas or views or perceptions on legalizing of abortion. Sometimes these interviews might change your own perspectives regarding the topic also. Okay, so again you can think of, okay, so I know the law in the country, I want to know what is there in Sri Lankan law, I want to know the perspectives of different stakeholders, and at the same time you may think that I need to know about what's happening in other countries also. I need to know about what's happening in other countries also. In that event, you can select comparative legal research method to discuss laws relating to abortion in selected jurisdiction. You cannot compare, according to United Nations record, we have more than 200 countries in the world. Okay, in the comparative analysis, you may not be able to discuss all different abortion related legislations in these jurisdictions. What you can do, you can select 2 or 3 countries for the comparison. Okay, simply looking outside to look inside. Okay. So you can extract best practices from, and then you have some knowledge about existing law, you have some knowledge about different perspectives of legalizing of abortion. Now you have some knowledge about different countries' legal mechanisms relating to abortion. Okay, then you can make a comprehensive proposal referring to Sri Lankan law. Okay, so this is how Sri Lankan law needs to be developed to legalize abortion into certain extent. Okay, addressing socio-legal, economic and cultural aspects of abortion, being a multicultural, multi-religious community. So this is how normally we conduct a research. Okay, so as I mentioned, there are different research methods, and different research methods are selected looking at the problem, and like when we prepare a problem, we have to unpack the problem. What is the law relating to abortion in Sri Lanka? Second question, what are the different perspectives associated with abortion in Sri Lanka? Third question, what are the best practice examples extracted from the sophisticated jurisdictions like UK, USA, and India, perhaps relating to abortion? And the final question would be, what proposals can be made to develop the law relating to abortion in Sri Lanka? Okay. To answer each question, you may need to select different research methods. Okay. So these are the 4 main legal research method. Okay. First one, doctrinal legal research method. Second one, social legal research method. And third one, comparative, kind of like, particularly belongs to legal research. Okay. Fourth one is interdisciplinary research. We can still use interdisciplinary research approach or method in a legal research. Okay. So now I'm going to briefly explain these 4 types of legal research methods. Okay. First one, doctrinal legal research method. Most of the lawyers, judges, law students, and even law researchers, they just follow this method even in their day-to-day work. A doctrinal legal researcher considers law as a self-sufficient and self-contained entity. Okay, so most of the time, what happens is that a doctrinal legal researcher only analyze, synthesize, and critically evaluate the existing knowledge of law, which can be found in primary sources and secondary sources. Primary sources means legislation and case law. Secondary sources means interpretative aids dealing with these legislations and case law. For an example, IP Act number 36 of 2003, is it a primary source or secondary source? IP Act number 36 of 2003. It's a primary source. Okay. So there is a famous book on elements of IP law in Sri Lanka, or fundamentals on IP law in Sri Lanka, written by one of the former directors of the National Intellectual Property Office. So that book, can it be considered as a primary source or a secondary source? Secondary source, because it provides interpretation of different sections of the IP Act. Okay, primary sources directly provide law, secondary sources interpret primary sources. That is what the difference between primary sources and secondary sources. Okay, so when it comes to social legal research, as I mentioned earlier regarding this abortion example, social legal researcher not only confined into answering a legal issue or a legal problem, but tries to discuss and analyze non-legal issues revolving around a central legal issue or central legal problem. For an example, what proposals can be made to legalize abortion in Sri Lanka? In that event, there are so many non-legal issues or non-legal problems to be solved before introducing a comprehensive framework, because that the framework in USA may not be suitable to be adopted as it is in Sri Lanka, because we have to contextualize these best practices, filtered these best practices, and then only we'll be able to provide viable and specific suggestions. Okay, at the end of a good research, you will be able to offer viable and specific suggestions. So what is the meaning of viable and specific? Viable? What is the meaning of viable? Viable suggestions. Suggestions which can be actually implemented in the particular country. Say for example, if we are doing a research to develop Sri Lankan law, we need to look at the fact that whether these suggestions can be really implemented in Sri Lanka or not. Okay, we can conduct a research on international law and say that, okay, the TRIPS agreement, trade-related agreement on trade-related aspects on intellectual property needs to be amended. However, from the adoption, like from 1995 to up until today, TRIPS agreement has never been amended. There were so many that the efforts to amend the TRIPS agreement, but all the amendments were failed. Only they introduced Doha Declaration. It is also a declaration and simply introduce Article 31 bis to the patent provisions accommodating that the access to medicine concerns of developing nations. That's it. So no point of making a suggestion in your research saying that TRIPS agreement needs to be amended in this way. Okay, that is why we need to consider viability. Sometimes you may be proposing a kind of artificial intelligence protecting or regulating authority for Sri Lanka. Maybe one suggestion. But we need to really look at whether we have enough expertise, whether we have enough financial capacity to introduce another authority. And also when we are looking at that the implementation process of different legal provisions in Sri Lanka, it is hardly possible to create a separate regulatory authority and make it functioning and that the accommodating, allocating whatever the necessary human resources and expertise and finance. Rather proposing a kind of a separate AI regulatory authority for Sri Lanka, what you can do is that if you need to make a kind of a very viable and specific suggestion in your research, what you can do is that you can consider the structure, existing authorities or structures in Sri Lanka, perhaps Data Protection Authority, okay, Consumer Protection Authority. Okay, rather going to a kind of a the standalone approach, we can make a suggestion saying that, okay, in the Data Protection Authority and National IP Office as well as Consumer Protection Authority, there should be a different departments or task force dealing with these AI implications on respective laws. It is a viable as well as a specific suggestion, okay, that we need to keep in the mind. Then empirical research or comparative aspect I discussed actually. So when it comes to this empirical aspect, we can couple the empirical aspect with the socio-legal research as well as interdisciplinary research also. So there are tendencies in legal research evolving. We combine into doctrinal type of legal research methods, so that the legal research decades ago, but now the tendency is that coupling qualitative and quantitative. Qualitative means analyzing existing legal material. Quantitative means collecting empirical data or first-hand information and use this empirical data to authenticate the existing knowledge and perceptions. Okay, so there is a kind of a trend towards amalgamating or putting together these qualitative and quantitative approach, or empirical and doctrinal approaches together in legal research also. Okay, comparative research method I discussed already. So we have to select countries with sophisticated laws or jurisdictions and then compare with the selected country's context. Okay, say for example, you are going to compare Sri Lankan law with the law of Madagascar, or perhaps law with Saudi Arabia or some other country. Okay, so when it comes to comparative legal research, we have to have very good, sound, solid justifications as to why we select these jurisdictions for the comparison. Okay, India you can select considering geopolitical similarities to Sri Lanka. Perhaps when it comes to data protection and privacy aspects, you can select European Union or one country in the Europe, considering the sophistication of the jurisdiction, because they have been pioneers of introducing data protection and privacy laws. Considering that aspect, that would be the justification, because without justification, we cannot select jurisdictions for the comparison. there should be a justification. The justification should not be a personal justification. I can share another example with you. I was at a panel at law faculty. This is a PhD, MPhil to PhD panel. That particular student has selected Ghana or some other African country for the comparison, actually. So two reviewers or the experts in the panel, they had a question in their mind, why you have selected Ghana for that particular African country for the comparison. That a student said that I worked there for 2.5 years. That is not the kind of a justification you can provide in a systematic legal research. Okay, so that justification should always be based on a kind of a solid reason. Okay, similarities of jurisdictions, geopolitical similarities, sophistication, or their contribution to the development of particular area of law would be much more like, the better or prudent justifications. Okay, so that the fourth research method is interdisciplinary legal research, or the research method. So to conduct an interdisciplinary research, you need to be well aware of different discipline-specific research methods. In that event, Dr. Malraj is in a kind of a better position because he is an interdisciplinary researcher. He has knowledge of two or more disciplines, okay? Because when it comes to interdisciplinary research, we just merge different discipline-specific research methods to answer one particular question. For an example, to answer a question relating to an area of law, rather confining into legal research methods or legal research specific, or that the legal law, legal discipline specific research methods, we can consider some other research disciplines also. For an example, we can conduct a medico-legal research in determining how Sri Lanka could introduce or can introduce a law relating to surrogacy in Sri Lanka, because surrogacy or whatever the decisions should not only be based on legal aspects. There are so many psychological, physical and medical aspects to be considered. Okay, so in the event when you are not having this interdisciplinary touch, what you can do, you can simply collaborate with one of your colleagues from other discipline. Like if you have a friend in medical faculty, you can do a research with your friend. He or she will be bringing this medical aspect into your research. You can contribute by using your legal discipline specific research knowledge. So ultimately the research would be a kind of a contribution in a based on a interdisciplinary research method. So this is an example, as you can see here. Look at the topic: conceptualizing the transnational regulation of plastics, moving towards a preventive and just agenda for plastics. Okay, as you can see here, I don't know whether it is visible. So there were the three authors from the law faculty or law school, one from Faculty of Science and two from School of Design. This is a very clear example for an interdisciplinary research. If you don't have the necessary knowledge about another discipline, what you can simply do is that you can simply collaborate with researchers from other disciplines and still conduct interdisciplinary legal research. Okay, so that is the first part. This is the second part. Perhaps we may not be able to discuss all the things because I'm supposed to finish the session at 10 minutes before 5 o'clock, right? Yes, because we have to have a Q&A session also. Okay, so when we look at the sources and legal databases, it is very important because without having a kind of a good knowledge about sources and legal databases, we may not be able to conduct a legal research. For an example, finding appropriate and more suitable sources for the work. This is also a skill needs to be mastered. I have seen at undergraduate level, not in the LLM or MPhil or PhD levels. So students tend to refer to Wikipedia also. So don't refer Wikipedia in your research because it is not a kind of authenticate or trusted source. But to obtain some kind of general knowledge about a topic, like if you really want to know about the concept of res ipsa loquitur, so you can simply refer to Wikipedia, but don't put it as a source or the citation in your work. Okay, I just wanted to emphasize that you should always be relying on authenticate, appropriate, and real sources. Okay, so there are two types of legal materials in a legal research: primary legal material and secondary legal material, which I have already discussed. Primary legal material, or that the primary sources, present the law itself. Secondary sources such as journals and textbooks interpret, explain, discuss, and comment or critique the law contained in primary materials. This is what the distinction between primary and secondary sources. Obviously, you can refer to primary sources and secondary sources. However, when we look at these different referencing styles, there is a hierarchy of referring to primary sources. Okay, so first you cannot refer to the Data Protection Act, then some regulations related to data protection, and then you cannot analyze constitution in your research. Okay, because hierarchy or SCOLA, Oxford Standard Citation Style, says that highest legal authority should be discussed or analyzed first in your research. So you have to start with the constitution, saying that we don't have a constitutional clause or that the protection for data, constitutional protection for data and privacy rights. Perhaps there is a kind of a possibility of the expanding the application of Article 12 of the Constitution, which is equal protection of law by way of the securing or recognizing and fulfilling data rights and privacy rights. Okay, then we can refer to the relevant legislation. Okay, so when we are referring to primary sources, if there is a kind of that the required referencing method to be followed, we need to know the nitty-gritty of this referencing style or method also. In Sri Lanka, we follow this British legal tradition, so SCOLA is the recommended referencing style. But in some universities, perhaps they might have developed their own the referencing style, like Ferradeniya Law Reference Guide. But in the Colombo University and Open University, I think in Law College also, I don't know what is the recommended the citation style in Law College, but our universities we follow SCOLA referencing style. Okay, so these are some of the examples for primary and secondary material. Constitutions, statutory law, international legal instruments, and case law are primary sources. Secondary sources: books, book chapters, journal articles, research reports or statistical report, thesis, and web sources. When we are searching for legal material, there is a method which we can follow. Okay, the method is called 4R method, or the 4R techniques. Okay, we need to consider four things. First, whether this material is recommended or not. Perhaps when you go through your course synopsis, so the course structure, at the end of the course structure you can find recommended readings. Okay, recommended by the authorities, recommended by the researchers, recommended by the teaching faculty. Okay, and then reliable. Who is the author? Is the author an expert of the selected field? This is very important. Okay, so most of the time I have seen that some of the PhD and MPhil level researchers, they just cite student researchers, like undergraduate researchers, in their proposals and academic work. Okay, so they have that in that event we have to be very careful in the sense we need to find like, that the salient or like key authors who have written more articles or more books or like, the published good research papers on a particular topic, and we have to always refer to the works or the contributions of these researchers first. Then we can obviously refer to students and other type of research work also. Okay, reliability. Then recent. Is it an updated material? Because I have seen, these are like, the life experience that I'm sharing with you. In the event you are doing a research to introduce AI or tackle AI implications on intellectual property rights in Sri Lanka, AI implications of intellectual property rights in Sri Lanka, perhaps you may be able to like refer to like some of the authors in 1950s just to explain the legal concepts relating to intellectual property rights, originality and copyright. You can refer to most of the now artificial intelligence on copyrights. You cannot refer to the works conducted in 1950s or 60s, even though artificial intelligence, the term coined in 1956 or somewhere at that time, legal research seems to be like having a kind of a very recent origin. Okay, sometimes in some universities, international universities, they ask you when you are conducting a research affiliated with this type of international universities, they ask you only to select research published within like 10 years of the time period, or like, prior to conducting your research. Okay, so it should be updated and relevant. Relevancy matters. Okay, when you are selecting legal materials, you can simply follow this 4R method. Recommended, reliable, recent and relevant materials can be used. And this is a kind of a very like, the interesting quotation that I have taken from Professor Simon Chesterman. According to Professor Simon, we must first acknowledge that bricks and mortar library we grew up with no longer exist as the center of knowledge, because you can simply sit in front of your computer. If you are lucky enough to like, that they get access to the most sophisticated databases in the world, even without stepping into a library, you can conduct or you can do a PhD research and submit it for the examination. Okay, without going to a library. But I always recommend to go to the library and like, at least to get that experience. Okay, but you can simply use the sophisticated databases like EBSCOhost, HeinOnline, LexisNexis, so on and so forth, and go through the relevant materials, most updated materials, authenticate and reliable materials, and then conduct a thorough legal research. So these are some of the e-databases for law research to find legal materials. Westlaw International, JSTOR, Social Science Research Network, SSRN, HeinOnline, Global Legal Information Network and LexisNexis Online. Most of these legal databases are subscription basis. Okay, subscription basis. So it is so pathetic, the situation in a country like Sri Lanka, we don't have access to these sophisticated databases. I also conduct research just only looking abstracts, because abstracts are the only portion available on the internet when we are referring to this cutting edge knowledge. Okay, this is something that we need to address at global level. Unfortunately, we don't have access to most of the most updated and cutting edge knowledge. But if you have access to these databases, the SSRN and JSTOR seems to be like, the free. Without subscription, you can just like go through these databases and find the relevant information. But LexisNexis, HeinOnline and Westlaw are one of the like most expensive databases. Sometimes you may be able to get a kind of like access through your institution or affiliated institution. So then you can refer to this Emerald Publishing, Taylor and Francis Online, Oxford University Press database, and Gesto and Hine Online have also listed here. So they also publish law books, not most of the time articles, but they publish law books. Okay, so you could peruse through these databases to find out legal resources, so that the legal material. And in Sri Lanka, we have this Law Lanka. LawNet seems to be not updated. They are in the process of updating also. That website is not very much like user friendly. This is my experience. I don't know about your experience. Perhaps like, that it is a task. It should be a responsibility of the government to like, that maintain an updated and user friendly legal database. Updated and user friendly legal database. So especially if you are not going to a like bricks and mortar library, so because we belongs to like different generations, okay, as I can see here, some of you might be like the millennials, they are Gen Zs, individuals representing Gen Zs there. So there are lots of like the different we are in different like the ages of our life. Okay, so in the event when you are using internet and computers and databases to like find relevant legal material, these are the things that you are supposed to know. Keyword search, advanced search, and Boolean operators. Okay, simply if you are supposed to write an assignment on this particular topic, critically evaluate the relationship between the TRIPS agreement and public health and its contemporary application. You can select these type of keywords: TRIPS agreement and public health, TRIPS agreement and public health in the time of the COVID-19. Just you could use these search terms on Google search engine to find out relevant information. Unfortunately, Google does provide like the most relevant information first. You may not be able to find like publish articles first. Sometimes you may be able to find out relevant blog posts and like videos and discussions and like UN reports and WIPO, World Intellectual Property Organization reports, on and so forth. So that is why we are supposed to using this LexisNexis, Hine Online, or Westlaw or other legal databases. Okay, when we use the same keywords in a legal database, we can extract the most updated, most relevant, and most reliable content or the material. However, since we don't have access to these databases, we could still use these keywords to extract knowledge from the existing knowledge. So then when it comes to an advanced search, there are advanced search options. We don't have time to like go through even like Google Scholar and find out these advanced search options. So sometimes you may need to like that the knowledge or that the material needs to be updated. In that event, in some search engines, you can select like the range of years, like from 2005 to 2025. Then once you conduct the like click the button, search button, you will only be finding the relevant sources from 2005 to 2025. Okay, and also in sophisticated databases, you can simply select names of the countries also. Say for example, an article dealing with TRIPS and public health published in the UK, or Australia, or India, or these jurisdictions. You can select the jurisdiction, then the search engine only purpose like the select articles relating to TRIPS and public health and dealing with Indian context, or dealing with the UK, or dealing with Australia. Okay, so advanced search provides you with more accurate, more reliable, and more recent or updated knowledge. Then So we have like half an hour more. Yes. So Boolean operators are a kind of like technical terms that we can use in extracting knowledge or materials using internet, especially internet databases. Okay. So there are three Boolean operators mainly, and, or not. Okay, so you have to use capital like letters when you are using these Boolean operators. Okay, so here in this table you can see the function of Boolean operators and the example also. Okay, when you use and provide results relating to all the keywords. For an example, when you use and to connect TRIPS agreement and public health together, the search engine will provide you with all information or published articles relating to both TRIPS agreement and public health. Okay. So when you use O only provides results regarding or relating to either keyword. Okay. If you use O in the context of TRIPS agreement and public health or TRIPS health flexibilities, you will be getting articles relating to both aspects, however, not dealing with the intersection of TRIPS and public health and the health flexibilities. Then, in the event of using not, exclude words from the search. For an example, when you use not in this context, TRIPS agreement and public health, not compulsory licenses, you will be getting materials or articles relating only to TRIPS agreement and public health. Okay, no article will be listed in the search list relating to compulsory licenses. This is a kind of a like, you know, the example you can use to like, you know, that to get a kind of a simple understanding about Boolean operators. Okay. When you use and, we can find results relating to both terms. Okay. When we use or, we can find results relating to either term. There will be a very long list. Okay. So when we use not, the results will only be confined into one term. Okay. So I don't want to confuse you. Okay. I just wanted you to explain the practical application of Boolean operators. Okay. So if it is confusing, don't use the Boolean operators. Just simply use this keyword or the keyword search and an advanced search. Just forget about Boolean operators. Okay, so each of the material or legal material serve distinct purpose. For an example, you can search textbooks to get basic and theoretical knowledge, to obtain basic and theoretical knowledge. You can use academic journals to find up-to-date research in the area and applications of theories. Okay, so you can use practical or the professional journals like Bar Association Law Journal, which can be simply categorized as a professional journal. Okay, to add interests and examples as necessary, because they just provide knowledge about practical application of different laws and areas of laws in the country. Okay, so internet relevant organizations, for an example, if you are doing a research on like vaccine equality in the time of the pandemic, how we can accommodate the concerns of developing countries, we can refer to World Health Organization database and website. And also we can refer to the World Trade Organization database. World Trade Organization provides one of the most enriched databases in the world. So you can even find like even discussions happened before the introduction of different agreements you can find in the WTO website. Each and every country's submission on a particular topic, like psychosensory measures, anti-dumping measures, so on and so forth. If you are really interested in WTO law, World Trade Organization law, international trade law, and other governmental departments and professional bodies also you can report. Sri Lanka Medical Council. Since we don't have any such regulation relating to surrogacy or life-sustaining medical treatment or informed consent or DNR related matters, to obtain at least some guidance, we can refer to the Sri Lanka publications, or the guidelines and ethics of the Sri Lanka Medical Council, professional organizations. Even by associations, publications can be referred in legal research. Okay, so this is the most important part when it comes to legal research. Okay, as lawyers, we are supposed to be like, that the following the legal ethics and principles even in conducting research. Okay, so research ethics and citations are very much important. So this is a kind of a very famous quotation by Sophocles. He says that, I would prefer even to fail with honor than win by cheating. I would prefer even to fail with honor than win by cheating, which means that when conducting research or doing research, researchers tend to engage in some unethical habits, follow unethical practices, sometimes illegal practices, because when we look at most of the research institutions and even universities, in Jayawardhanapura University, they have copyright and plagiarism policy. In Colombo University, they have copyright policy. In Open University, we have copyright and fair use policy as well as an IP policy. Okay? So these policies prohibit some of the unethical practices associated with research. Okay? Like cheating, deception, fabrication, and plagiarism. Cheating, deception, fabrication, and plagiarism. Nowadays, so students tend to, like researchers tend to, like provide fake information in research. There are so many examples. I'll share one example with you. I was asked to mark a dissertation submitted by an LLM student in a particular university. So I went through the dissertation, so that the topic of the dissertation was on copyright protection in digital platforms. Copyright protection in digital platforms. So I was asked to mark this, examine this dissertation. Then I went through the dissertation, like when I'm like, when I was going through 2-3 pages of the dissertation, I found an interesting reference. This particular article was written by one of the Sri Lankan authors, published in the International Journal of Intellectual Property Law and Practice, so International Journal of Information Technology Law, Harvard Journal, Oxford Journal of Information Technology Law. Then I stopped going through the dissertation. I went through all 25 citations, published articles in reputed index peer-reviewed journals, some topics similar to the topic selected by this particular candidate. In Sri Lanka, there is only one Sri Lankan published in the Journal of Information Technology Law, that is Dr. So now she is an associate professor, Kanchana Karyavasam in Griffith University. Other than that, no one else in Sri Lanka has published in this type of reputed journals like technology journals. Okay? That particular candidate or that the student has used artificial intelligence or a kind of a related technology to create references relating to her topic. Okay? That action comes under all the different forms of that the academic malpractices. Cheating, deception, fabrication and plagiarism. Then I was supposed to make a complaint to the higher degree research committee saying that, so this seems to be that the fake, seems to be fake citations, so I can't mark the dissertation. I didn't give a pale mark, I give a mark which may not be able, because I can't give a pass mark, because I know that the student has provided some kind of fake citations, then it went to the academic board. I don't know what happens after that, but I wrote in the thesis or the dissertation saying that, so this needs to be stopped actually, otherwise students will be cheating and fabricating and provide plagiarized content for the examination and ultimately get the qualification and say that, okay, look, we have an LLM from this prestigious institution also. Okay, so we need to be aware of, we should not be rejecting the development or that the technological advancement. We can't do that because we have to step together with the development of technology and advancing technological aspects. So we are living in an AI era. We cannot say no to AI. But the thing is that, so we need to be mastering the qualities of how to use artificial intelligence and related technological advanced technologies ethically and responsibly. Okay, so that's a kind of a need to be addressed. So what is the meaning of plagiarism? So according to this particular online dictionary, there are 4 meanings. 4 meanings given, each meaning complementary to other definitions also, as you can see here. Plagiarism means to steal and pass off the ideas or words of another as one's own. Stealing an idea of someone else's and then pretend that idea belongs to the researcher without acknowledging the original source. Okay, which comes under the purview or the definition of plagiarism. In a plagiarism, a researcher may be doing 2 wrongs. First one, stealing someone else's work and lying about it afterward. Stealing someone else's idea and lying about it afterwards. We pretend that I'm the original owner or the author of this idea in an event when we are not putting an acknowledgement. So there are plagiarism policies in different universities and institutions. Therefore, plagiarism is an offense, so that the unethical research or the conduct. Okay. So when it comes to paraphrasing, what do you think? You can use your own word to explain or describe someone else's idea. Then you can argue that, okay, I used my own words, therefore I am the owner or that the author of this particular idea, and they should not be acknowledging or I am not supposed to put any citation or reference to this particular idea. However, still paraphrasing is considered to be as an act of plagiarism, because even though you use your own words to explain something, that idea still belongs to someone else. Okay, perhaps Professor Ronald Dawkins says that, the center, Eugene Ulrich says that, center and gravity of law relies in the society itself. Law should be a mediator, balancer, and harmonizer of the conflicting interest. You can use whatever the terms you like to explain the same idea, but still the idea belongs to Eugene Ulrich or Ronald Dawkins or Roscoe Pound. So you are supposed to acknowledge the owner of the original idea. Otherwise, paraphrasing is also considered to be as an act amounting to plagiarism. So what we can do? We are supposed to paraphrase. Sometimes we are supposed to explain someone else's idea to make points and arguments. So we can't avoid paraphrasing in legal research or whatever the research. So to make it not amounting to an act of plagiarism, what we can do? We can use references just to acknowledge the original authority or the original author. Okay, so that the correct referencing can be used to minimize or prevent plagiarism. So these are the the benefits of using references. Okay, to avoid plagiarism, this is the most important benefit of using references. To credit the author, original author, to show the original source, to demonstrate your knowledge also. Okay, so if you have so many references in your work, you could show that you have a thorough knowledge about the selected area or the subject. Okay, but don't put unnecessary citations. Okay, perhaps you might remember when we are discussing about this 4R concept. Okay, the 4th R referred to the relevancy, the concept of relevancy. Okay, you are supposed to be citing only the relevant content. You are supposed to be putting only the relevant references in your research work. Okay, that can be done like using 2 references, rather 10 references which are not directly relevant to the area that you discuss. Okay, like regulating sperm and organ donation in developing countries. Okay, you can cite health law books, but it is not necessary to cite health law books because you need to consider the relevancy of the sources that you cite. Okay, so you can show the knowledge by using references, but with putting the relevant and necessary references, and then to lend credibility to your work also. Okay, in the event you have selected most important, reliable and updated sources, it would be an indicator of lending the credibility to your work also. Relevant citations, updated citations, and key authors' works. When you cite key authors' work, it provides some kind of that the credibility to your work, an indication about you have referred to key authors, recent works, and most cutting edge research on the selected topic, and then this argument seems to be solid because of this good foundation, that the solid foundation. Okay, so these are the benefits of references. There are 2 phases of references. Citing 2 phases in referencing: citing an authority, making a reference, or that the list or a bibliography. There are 2 types of referencing. When you are following Harvard and APA style, we use in-text referencing, like within brackets. Okay, Vijay Singh, 2025 within brackets. Okay, APA style normally use in-text citation, but in the event we use OSCOLA, Oxford Standard Citation Method, and AGLC means Australian Guide to Legal Citation, we use footnotes rather in-text citations. Okay, you cannot use in-text citations and footnotes together. Okay, it is an indication that you might have taken some parts of your work from some other sources and put them as it is in your thesis or the dissertation. Okay, if there is a particular citation style or method explained or provided in the guidelines, you are supposed to be following the required guidelines. So this is your scholar referencing guide, especially 4th edition. We need to refer to the scholar 4th edition. And in the 4th edition, the Oxford University Standard for the Citation of Legal Authorities, in the 4th edition, we don't have any guidance relating to international, how to cite international sources or international legal standards. Only for that part, you need to refer to the 2006 edition, which means the 3rd edition. Which means that you needs to be thorough about OSCOLA 4th edition as well as 3rd edition. 3rd edition has a specific reference to international legal sources. Okay, so that is about referencing. I actually asked this question from ChatGPT today morning. This is what the question of the prompt. Do you plagiarize? This is what the answer, very clever and cunning answer given by ChatGPT. No, I don't plagiarize. Very direct. No, I don't plagiarize. Okay. So everything I generate is original content created in response to your prompts. I don't copy from specific sources unless you explicitly ask me to quote or cite something. And even then, these are like exemption clauses. Okay. I will let you know where it comes from. I will let you know where it comes from. It is not my duty. That is what the implication. It is not my duty. It is your duty to authenticate the original sources and put the relevant citations. My task is to gather and provide whatever the necessary information that you request. Okay, ChatGPT puts the blames onto you. Okay, then when I provide information, it's synthesized based on the vast range of data I was trained on, but I don't reproduce texts from copyrighted materials or website. There is another threat of heavily relying on AI to create content, especially for submitting your academic work. Okay, so artificial intelligence, ChatGPT expressly says that I don't rely on copyrighted materials or websites. So most of the authenticate, reliable data is published on copyrighted websites and copyrighted journals. In that event, we cannot 100% rely on AI generated content. Okay, so this answer, if you are ever using something I generate for academic or professional purposes, I'm happy to help you replace. Replace means paraphrasing, cite sources properly, or to make it more humanized version, provide a kind of a more humanized version, and then or check originality, just let me know. Okay, so this provides a kind of a very powerful message that we should only be using artificial intelligence just to gather information and find the places where are necessary to be looking at, but not for the purpose of write an email, to reply to an email, okay, to write a LinkedIn post or a post in Instagram or somewhere else, you could use artificial intelligence. Okay, to find relevant sources, to find relevant reports, to find cutting edge research findings, you can use artificial intelligence, but not to write your thesis or assignment. Okay, so this is a message that I wanted to give you in this session. So use the technology, but ethically, in an ethical and responsible manner. Okay. We have 9 minutes more. So, and I'll be like, that the very, very quickly and briefly touching some aspects of case-based research techniques. So writing case notes is also a part and parcel of legal research and the academic work. Okay, if you are an intern in a law firm, or if you are supporting your senior counsel or a senior lawyer to find relevant case laws, perhaps you may need to write case notes. Okay, so a case note is something that every law student is asked to write at some point in their studies, and without some direction can be a daunting task. Okay, it needs to have some direction. There are different aspects in a case note. I have divided all different aspects into two poles, at the two categories. In a good case note, we need to have these two aspects, case summary and case analysis also. Okay, case analysis is the part where you need to invest or utilize your own analytical skills and your knowledge about law. But in the case summary part, go through the case and find out that the relevant dates and parties, if there is a ratio decidendi, what is the meaning of ratio decidendi? Substance, or the substantive aspects of the case, an obiter dictum, there can be an obiter dictum, or perhaps there may be some other aspects like dissenting opinions. There may be sometimes the dissenting opinion might be the most important part of the decision also. Can you give me an example? We only refer to the dissenting opinion in these decisions, rather referring to ratio decidendi, or the majority decision. Yes? Sorry? Yes. Justice Veeramanthri's, Professor Veeramanthri's dissenting opinion, and even in Hungary versus Slovakia case, we only refer to the dissenting opinion of Justice Veeramanthri, rather referring to the majority opinion, like discussing about twin demands of sustainable development, how this ancient wisdom can be utilized to inform that the modern laws about sustainable development, so on and so forth. Okay. In the case summary part, we can simply go through the case and discuss about what is there in the case. But when it comes to the analysis, you have to invest your own knowledge, or you have to use your own abilities to provide an analysis. These are the aspects that we can discuss in a case summary: facts, procedural history, ratio decidendi, obiter dicta if any, and dissenting opinion if there is a dissenting opinion, or if there are dissenting opinions. And in the case analysis, we need to discuss about critical aspects, implications, and conclusions also. Critical aspects means whether the decision of the court can be considered as right or wrong. Okay? Whether this decision in lines with existing legal principles or not. Okay, sometimes that the Jackson Industries case, which is a very recent case, overruled Roe versus Wade case regarding abortion. When it comes to the analysis, so you can be very critical and discuss about whether this not. If not, you can discuss about the implications also. If it is a better decision or a good decision, or if a decision can be considered as a traveling jurisprudence, then you can discuss about the future implications also. For an example, Jayarajan versus Jayarajan. Best interest of the child should be a paramount consideration in deciding whatever the thing relating to a child. Okay, Bulankulama versus the Secretary to the Ministry of Industrial Development. Okay, even though Sri Lanka is considered to be as a dualistic country, even though there is no such concept such as the pure dualism right now, because almost all the dualistic countries seems to be creeping towards monism. Okay, just to recognize international legal principle. Iterated that, or that they emphasize in the decision that we cannot simply neglect the obligations, UN obligations and environmental protection related principles, even though we heavily rely on the concept of sovereignty of parliament and dualistic approach. Okay, so these type of that the far-reaching consequences of judicial decisions can discuss on the case analysis part. So these are some of the questions that you can ask from yourself in the analysis part. If you really want to provide an analysis, kind of a good analysis, so thorough analysis, is the logic of the judgment is sound or not? Does a judgment differ or depart from previous decisions? Does a judgment reflect political, economical and cultural tensions? Does a judgment fail to acknowledge any legal or extra-legal repercussions it may have? Has the judgment failed to address any important questions, and do you agree with the decision? If so, why? If you are not agree, justification of the reasons for that also in a case analysis part. So these are two types of practical tactics that we can use in that the reading very long, lengthy articles and documents, because I know that even I don't read most of the time almost all the pages in an article. Okay, I just skimming and scanning through the articles and relevant legal materials just to find out whether I'm supposed to be reading the entire article or not. Okay, if I'm satisfied with the first that the screening results of the first screening, then I opt to read the entire article or the book chapter or the blog post. Okay, so skimming means to get general idea of the content or structure of the text. Assume a scenario like you have just found 30-page journal article titled Legal Responses to Artificial Intelligence in Healthcare. 30 pages are there. You may not be able to read all 30 pages. So how to skim? Read abstract, introduction and conclusion first. Abstract, introduction and conclusion first. Okay. Do not go into the the substantive parts or the context. And then glance at headings and subheadings. Read the first sentence of each paragraph to get an idea about each paragraph. Okay, this may not be that the easily cannot be easily done, because sometimes writing styles of authors can be different. Normally, authors following the UK tradition, they tend to use the first sentence to indicate the argument. They start research saying that the main objective of this research is to analyze the impediments of implementing or legalizing abortion in Sri Lanka. That is how they start the research. But there are some researchers who just provide like background and context and theories and so on and so forth. Then only at the end of the work, they just mention the objective. Okay, so that the reading the present tense of each and every paragraph may not be like, that the a kind of a prudent advice, but sometimes you may use that tactic also. And then ignore details evidence and decide whether the article is relevant to your research or not. And the second tactic is scanning. Assume a scenario that you are looking for a specific case or legal reference on data protection in AI applications with the lengthy report. So you could use this control plus F function, find function, and type keywords like GDPR, General Data Protection Regulation, or data protection or privacy, where in which like, you can go through the report simply where in which this particular term is mentioned. Rather like, going here and there and wasting your time. And then move your eyes quickly down the page looking for dates, case names and statutes. Check tables, figures and put notes if the information is likely to be cited there. Rather reading the entire report. So you could use these scanning and skimming methods just to find the relevant and most important information in legal material. These are the tips that I'm not going to discuss because of the time constraints. So you need to have mental and work-life balance also to success in the field of academic and research. Okay, so that is where I just wanted to emphasize all other things relating to research work. Okay. That's it. We discussed about fundamentals of legal research and identified different legal research methods: doctrinal, empirical, socio-legal, comparative and interdisciplinary research. And then we identified legal materials and different databases we could use to find legal material. And then we discussed about different tactics, and also we discussed about two things needs to be included in a case note: a case summary and a case analysis. Okay, I hope this discussion provides you with an overarching idea about legal research. Okay, we have to have like more than 20 sessions like this to discuss all these, the entire gamut of legal research, but we don't have that sophistication, okay, that luxury to like sit in a room and discuss these things again and again. Okay, so I think we still have time, like we can utilize 5 minutes for questions and answers. If you have any question, you can simply ask. I'll try my best to answer within 5 minutes. Any question or clarification? Yes.
Hello, sir.
Hi.
Good to see you again. And recently, I've gone through this legal research model review, which done by Amartya D. Silva, PhD scholar, under the name of Desk Review and Basic Field Data on Child Marriages, Statutory Rape under age 6. So in the appendix, they have mentioned some case studies, more like an oral context, which are reported by relevant medical officers.
Yes.
In relevant medical regions,
Yes.
just like Berikalo, Mana. So how far is it possible to do the same in a legal research? I mean, okay.
Yes. So that's a kind of a very good question, very pertinent question, because we didn't discuss about this research ethics part, research ethics relating to legal research. So yes, obviously, the recent trend is that legal research seems to be like, that the involving and the developing with different other disciplines and research methods, especially to authenticate existing knowledge. We can conduct research like surveys, interviews, focus group interviews, key informant interviews, so on and so forth. But when we are going to collect sensitive and confidential information, if the information collected comes under the terms of confidential and sensitive, we have to follow an ethical approval process. In research institutions, they have ethics approval committees. Okay, before conducting an interview, we need to we need to fill an application. In that application, even we are supposed to, we are required, not supposed actually, we are required to submit the interview questionnaires to the ethics review committee. Then the ethics review committee go through these questionnaire forms, and then they provide recommendations to be included in the interview process. Then only we can conduct interviews. For an example, if you are going to interview rape victims, just to provide some suggestions on how their rights and their dignity can be protected in an open court, what provisions need to be included in the existing legal procedure, criminal procedure, or the law relating to criminal law in Sri Lanka. In that event, the interviews need to be conducted very strictly following these ethical and moral guidelines. Okay, so under an ethics review process, we can conduct a legal research. There is no doubt about that. There are so many legal research conducted by using this sensitive and confidential information. I'm supervising one PhD student. She has interviewed many prisoners in almost all prisons apart from this Bose detaining center or the prison. She visited all the prisons and interviewed at least 5 prisoners from each prison. Her research topic is protecting right to health of the prisoners in Sri Lanka, a comparative legal research or the comparative legal analysis. Yes, we can conduct empirical research and authenticate the data of legal research.
Yeah.
Yes,
My
sir.
question is, now you might have known the US is changing policies
Yes.
and all the European regions and throughout the world. So how do recent development in countries' policies or legal landscapes influences the validity, the applicability, and the generalization of your research results? That means, at one point, a country might have not influenced a policy or a bill or a legislation when you're writing your article and you're publishing at that point. But then the country introduces it, then the country brings out the bill, then your validity is kind of attacked. So how do you manage that?
Yes, so there's a simple way to address or tackle this issue. Okay, what is the most simple way is that to mention you have analyzed or discussed laws relating to this particular topic up until this particular date. Okay, if the development happens after publishing or conducting your research, that may not affect to the ideas or the arguments in your research. Okay, normally PhD students do that. In a kind of a separate page, they mention the date of the analysis date, whatever the laws relating to this particular topic as analyzed relevant to this particular date. That is the most simple way to tackle this, because law is evolving and that the societies are changing. So we cannot prevent that. The only way is to mention it very clearly in your research paper or the thesis. Yes, we can have only one question. Okay, we are supposed to be finishing at 5 o'clock. Yes.
Good evening, sir. I believe a legal academic or a lawyer would be concerned about a topic and will do a research at a point when he or she thinks that a law should change or some law should be introduced to the country or there should be some implementation in the
Yes.
country having that mindset,
Yes.
whatever they think they should gain at the end.
Yes.
So I just have that, I understand the fact if you do a successful research, that should be like, following all those things that you have done. Do you think the legislature, when they make laws, will refer to your research? Now, if you do a good research and if your legal academics at the ED department and justices and whoever the one who will read your research might agree with your point. But then to change the law or to introduce the legislature also, like, they should support in some way to consider your research. So I basically thought when I was like, studying law, it's only through courts and the, justices can add something to the law, not by legal research. So that I had in my mind, but after looking at your research, I changed my mind. So what would be your, in the sense like when a lawyer go to the laws based on our interpretation, how we present it to the justice, maybe we might add something to the law. Yes. And if you are a justice, so if you're in a judicial position, you also can add something to the law. But apart from that, do you think a legal researcher can do a successful research and that would be considered by the legislator in the country? And simply because you have done only a research successfully, that would implement the law or add something to the law, like I was...
Yes, so that is also a very important question. So, yes, so when we look at Sri Lankan context, we are, like, our research seems to be very rarely considered in the lawmaking process, okay? But in other countries, they have, like, that the connection between the lawmakers and research institutions and policy institutions. For an example, in India, they have the Center for WTO Studies and World Trade. This center provides almost all research and consultations need to be considered by the law and policymakers in the country regarding international trade law. Even before concluding FTA, free trade agreements and like bilateral and multilateral trade agreements with other countries, Indian government consult this institution, which is considered of like world-renowned legal scholars. So they just attend the consultations even with the government officials, like relevant ministers. They present their ideas. They just provide like that their own research findings, and then only the FTA, or that the free trade agreement and the law is decided. In Australia, they have a process of like that the consultation, public consultations before lawmaking. For an example, so they appoint subcommittees at the federal parliament. These subcommittees visit each and every state before implementing a law. They just introduce the draft, visit each and every state. Each and every state parliament, general public and especially law academics are given opportunities to present their findings and their proposals to the proposed law. Okay, then subcommittee note all these things and go back to the parliament. Then they revised the draft, and then only the law enacted as final, like the law of the country. Okay, so those are some of the mechanisms which we are supposed to be adopting in Sri Lanka also, because we also conduct cutting edge legal research, but unfortunately these research do not reflect in the lawmaking process. Okay, thank you for the question. So we need to like change our attitudes and the way in which we work in this country. That is how we need to reach. Yes, okay. So now the question and answer session is over. So thank you very much for inviting me, and I'm really happy to see you all and to share my knowledge about research, legal research and legal research methods. Thank you very much.
Thank you very much, sir. To honor and express our gratitude, we now invite Dr. Malraj Kiriella, the chairperson of BSL Standing Committee on Law Student Skills Development, to present the token of appreciation to Professor Sanath Samira Vijay. Thank you, sir. There are two notices. So first, we have published a link to a Google form where we are collecting feedback on the session from you guys, and there were some questions that you guys couldn't answer from the professor. So please, kind enough to share them on the WhatsApp group itself, which we will forward to professor and get you answers. So to formally conclude today's proceedings, I now invite Mr. Sarans Jayawardena, Assistant Secretary to the Bar Association of Sri Lanka, to deliver the vote of thanks. Please welcome him.
Guest speaker this evening, Professor Sanath Samira Vijayasinghe, Dr. Malraj Kiriyalla, Chairman of the Law Student Skills Development Standing Committee of the BASL, and the members of that committee, my colleagues in the audience, ladies and gentlemen. It's a pleasure to be here today and to have the opportunity to deliver a vote of thanks at the inaugural workshop organized by the Law Student Skills Development Committee after such an engaging and insightful session. First of all, I thank our guest speaker, Professor Sanath Samira Vijayasinghe, for taking time to be with us and for sharing your expertise on learning and research excellence. Your insights will no doubt go a long way in helping both the lawyers and law students in the audience sharpen their legal research skills. Whether it's academic work, litigation, corporate practice, or advisory roles, and the tools and techniques you have shared today will of immense value in respective fields. I thank the President of Bar Association of Sri Lanka, Mr. Rajiv Amarasuri, Attorney at Law, for his direction and guidance. I would also like to thank Dr. Malraj Kiriyalla, Chairman of the BSL Standing Committee on Law Students' Skills Development, and the other office bearers and members of the committee for putting this workshop together. And also I thank our refreshment partner, Ceylon Cold Stores PLC. And also I would like to thank the President, office bearers, and the other members of Sri Lanka Law Students Union of Sri Lanka Law College in coordinating this particular event. I also wish to thank student unions of legal education institutions across the country for their support in coordinating this event. I also wish to thank Mr. Pasindu Valpitigama for comparing this event, and also the media unit of Sri Lanka Law College for their valuable support and coverage. A warm thank you to all participants as well. There are participants in the audience as well as who are joining this program through Zoom. Your presence and engagement are what made this session so interactive and meaningful. I would also like to thank the staff of the BASL for the logistical and technical arrangements. We look forward to see all of you all in future workshops. There would be, this is a series commenced, there would be so many more workshops of this nature which will assist you all for your career progression. So please join in all those programs. Thank you.
Thank you very much, sir. So, ladies and gentlemen, that concludes the formal segment of today's event. We kindly invite you to enjoy the refreshments, which will be served outside the auditorium as you leave. As we conclude, we humbly remind you to dispose all waste and disposable items responsibly in the bins provided. On behalf of the BASL, LSU, and the Standing Committee on Law Students' Skills Development, thank you once again for presence and participation. We wish you a pleasant evening and look forward to seeing you in the future session as well. Have a very great evening. Thank you very much.